I am Meena Panikkar. I teach in the Faculty of Law, University of Delhi. The module on which I would be speaking today is the role of judges in the Indian polity, law, politics and the court. This module basically looks at the interface in between law, politics and the court, and it's analyzing how the law or legislations and the court and the interrelationship, to what extent the court has anything to do with the legislations or the lawmaking activity, and whether the court is involved in the political process of the country, and to an extent is looking through various decisions of the Indian Supreme Court from time to time, and to what extent they have entertained those political questions even before the court. Now, at the very outset, let me tell you that there is an aversion when one tries to link politics with the court as an institution. To suggest that the judges are immune from politics, or the politics is the realm of political parties or the politicians or the ruling establishment, but not of the court or the judiciary for that matter. And this module therefore looks at if there are possible interfaces in between, or to what extent this averse attitude is right to be sustained. So, one of the first points we look at is the interface among law, politics and the court. One of the classic works on suggesting this interface is by Professor Ubendra Bakshi. He wrote on Indian Supreme Court and politics, where he says the judicial process is a species of political process, and therefore, there is an inseparable link in between both these processes, and constitutional adjudication itself is a matter of political activity. Now, how does he suggest that the court is having that interface, or the judicial process is a part of political process? He says the court is a center of political power, and when one looks at the explanation how it becomes a center of political power, one can see that the actions or the functions discharged or the duties performed by the judiciary actually set the politics in motion. He says there is an influence of agenda of political action. The judiciary actually influences the agenda of political action in terms of reading down the laws when it is needed, or declaring the certain executive actions as illegal, or when it strikes down statutes because it lacks constitutional permissibility. So, one can see that basically through the review of legislative or executive actions, the court is setting the agenda of political action for governance of the country. This could be through a variety of means, but whenever the constitutionality of an executive action or a legislative action is under dispute or has been challenged before the court's decision then will set the agenda for subsequent action by the government. There could be instances where the executive or the legislature tries to overcome the impact of judicial decisions, but then the broader level one could say that the judiciary plays a crucial role in declaring the executive legitimacy of the executive or legislative actions. The court is vulnerable, which Professor Bakshi says here, the court is vulnerable because it has no constituency of its own. Unlike in the case of parliament, the lawmaking institutions where the representatives come through an election process, so they have a constituency to be accountable to. In the case of judges, there is no appointment of judges, are not elected, they are appointed through a selection process, and therefore, there is no constituency and therefore, there is no accountability to that particular electorate. There are different types of constituencies in the case of judges, because they, through their judicial decisions, they would be targeting a particular group or individuals, and for whom therefore, a constituency is created. So, to that extent, though they do not have a constituency like of the parliamentarians, they have a constituency of a limited kind, which is consisting of the people who to whom they have given the decision. However, the decision given by the judiciary still needs to be implemented by the executive. So, the execution of those decisions is left to the will of the executive, and at times one would be looking only externally or superficially, we would be looking at the judicial decisions, but the follow up actions which needed to be taking place are to be done by the executive, and which quite often takes a number of years more. Because the judges are not elected, but appointed in countries like India, there is the criticism that the court wields power without accountability. The court has a limited constituency of its own, which consists of the people for whom the decisions have been made by the court. But then it is another matter to see that how the court's decisions are implemented, for which the will of the executive is needed. So, superficially we say that the judicial verdicts are out and or why decision has been made by the court, but whether actual relief has been received by the parties concerned, that will take years in many cases, because it is depending upon the will of the executive. One of the criticisms which have been levelled against the court is that the court wields power without accountability, and accountability is looked upon in terms of fighting elections. The notion is that the elections will ensure that the representatives of the people have to meet them after every 5 years, and therefore, there is an accountability with which they should handle their functions. In the case of court, there is no fighting of elections involved, and therefore, their decisions are ones without accountability. But Professor Bakshi argues that judges with high craftsmanship and statesmanship effectively exercises political power, while maintaining that they are really interpreting the constitution or law. So, through the mechanism of judicial review of executive or legislative actions, the judge still could exercise political power, though under the guise of interpretation of the laws or the constitution. So, whenever the constitutionality is challenged, the interpretation given by the judges could be a method through which the judges could exercise their political power. Now, Supreme Court is a major institution of national government when one looks at it in the Indian context. It is having the power of making the law or making or unmaking the constitution. This is in the context of saying about the power of judicial review. When the legislation is challenged because of its unconstitutionality, this unconstitutionality argument comes up on two accounts: because of the limitations on the power of lawmaking in terms of lack of legislative competence, or is being made in violation of fundamental rights. Both could be the reasons for the court to interfere in case of a challenge and see the constitutionality of the particular statute. It could also make or unmake the constitution in the sense that many of the constitutional amendments have been challenged before the court, and from time to time the court has either declared those constitutional amendments are valid or been struck down because it was not in accordance with the spirit of the constitution. Now, though the court is performing these functions in terms of making or unmaking the constitution, many a time one could see that the court refuses itself to be intervening into the policy matters, is also becoming a facilitator for the performance of other organs of the government, the legislature or the executive. So, there is a balancing power which has been ensured by the court in certain cases to suggest that the other organs of the government would perform in accordance with the tasks being assigned to them under the constitution. To that extent, the separation of powers envisaged in the constitution is taken due note of by the judiciary. One can see that the court is kept busy by the state or the government. The government is the biggest litigant before the court, and the government is to also perform the role of administration of justice and enforcement of law. So, on the one hand, one can say that the court would strike down any unconstitutional statute or executive action, but it is the government which is together with the court performing the role as administrator of justice or enforcement agency of law. So, the executive has the role to see that the law enacted by the legislature, not been struck down by the judiciary, is needed to be implemented in practice. But the court has also come across, as Professor Bakshi points out, a number of instances where the court has been burdened, where it should have been for the executive to make a decision, but then instead the executive passes on the burden to the court for the final decision making. Particularly, he brings in the cases discussed under Article 311 of the Constitution with respect to civil servants and disciplinary proceedings, or in instances even a compensation package which is to be given to the widow. Ultimately, the judicial intervention is needed for the final disposal on the matter. So, these are instances where which show that the government becomes, the executive becomes the biggest litigant before the court. The court also plays an oppositional role of politics, and it is also to suggest that every judicial question becomes political question, and many a time the court has been resorted to by the necessary stakeholders as the last political recourse, to suggest that the court is not the place of last legal recourse, but also of a last political recourse. This was been discussed in the context of the famous A.K. Gopalan case, the cases of the detention of Naxalites under Article 22 or using Article 22 of the Constitution, or the minorities approaching the court for safeguarding their linguistic and religious rights under Article 30 of the Constitution, which shows that different dimensions of the court's role, and which all have political dimensions attached to it. The political parties, for instance, could question the legitimacy of the executive action by taking up the matter before the court. It could also see that where the parliamentary, the representative institutions could have been the ideal place to see that those discussions take place, but then the court also has been brought into the picture in order to see that the constitutionality could be guarded by the court given an opportunity to it. And to that extent, it becomes a place of last political recourse. So, in the case of A.K. Gopalan, it is very evident that the detention order of the executive was challenged before the court, where one can see that it is involving deeper political questions. Similarly, the treatment of Naxalites, detention procedures under Article 22, and the rights of minorities discussed under Article 30. There are instances of the court's intervention to safeguard those rights. There are a number of rights, number of cases which have come up before the court from time to time in order to see that to what extent the court has involved itself in discussions which are otherwise political in character. So, one could see that the court has one is about looking at the place of judiciary in politics, or whether there is an interface the law is made essentially by the representative institutions, but the legitimacy or constitutionality of the law is decided by the court. The politics actually will be a platform through which the laws, enactment of the laws would be played, because one can also see that the judiciary plays different role. For instance, there are writers who suggest that there is partnership in between judiciary and the institutions of lawmaking. For instance, the common law principles are developed to a large extent in which the court was the senior partner, but in the case of enactment or the laws made by the parliament, the court could be considered as a junior partner, because the legitimacy of those laws could be looked into and examined by the court. But whether it is a partnership or not, one can see that to a large extent the laws are not detached from politics, and the courts play a key role in bringing up or accordingly devising a strategy of action for the governance of the country. It could also be seen that the appointment of judges, whether it is away from any political interference, externally one could see that with the presidential reference of 1998, appointment of judges, the essential criteria, the methods, procedures are all spelled out by the Supreme Court. But the recent Judicial Appointment Commission Bill actually raises that issue further, to what extent the executive have a say in the appointment of judges, or whether the judges could be appointed through a collegium system governed by the judges themselves, and to a large extent whether it will raise issues of accountability on their part. But this the Judicial Appointments Commission Bill therefore suggests a combination of members where executive and judiciary will play a balancing role. So, there were instances where the supersession of the senior most judges happened, and chief justices were appointed not based on seniority, thereby suggesting a scope for political intervention. But with the collegium system in place, to a large extent the issues of that kind were settled. But again, with the Judicial Appointments Commission, we may be able to get an opportunity to see how executive and judiciary will perform the balancing role. The law and politics dispute could also be looked at from another angle, in terms of the number of cases which have come up on different items, which in some cases the court was able to give a relief to the parties concerned, but being overridden by the exercise of power, legislative power by the parliament subsequently. There could be cases where the court did not proactively act in terms of routing a political course accordingly. There were instances where the Supreme Court had intervened actively to uphold the constitutional ideals. So, there are a number of cases, a few of which would be discussed now. We had the Shabanu case, where a Muslim woman was abandoned, divorced by her husband, and then sought a maintenance under the Code of Criminal Procedure section 125. The Supreme Court had given relief to a Muslim divorced woman, Shabanu, when she approached the court for maintenance, and then appeal was taken by her husband to the court. The High Court had given her a relief, but on appeal by the husband, the Supreme Court affirmed the award of the High Court. It said that the section 125 of the Code of Criminal Procedure, which gives maintenance, which has a provision for giving maintenance to all vulnerable sections, including children, parents, old aged, and it included even the Muslim woman, to suggest therefore that the Muslim woman cannot be exempted because she belongs to the minority and she should be governed by her personal laws. This was an instance wherein the parliament tried to overcome the effect of the judgment by enacting a legislation subsequent to the judgment. The critics have actually argued that whether that could have been the right course of action taken up by the parliament, where bulk of the Muslim community still, particularly the women in that community, live in vulnerable conditions. To that extent, whether one could have been arguing in favor of the personal laws or overcome the effect of the judgment through a specially enacted legislation. But Shabanu case, the Supreme Court did did look at the issue positively to suggest that a Muslim community cannot take the exemption clause of personal laws. The ordinary law of the land should be made available to them in case of vulnerable sections are involved. In the election case of Mrs. Indira Gandhi during the time of emergency is another instance where the court came up with, court had to face this issue, to what extent certain practices which she is alleged to have done during the time of election campaign could be falling out of the provisions of the Representation of Peoples Act, and accordingly the constitutional amendment she brought in subsequently. The court actually had an opportunity, but then it could also see that it did not have the necessary, it was more concerned, as Professor Bakshi argues, that it was more concerned about the survival of its own institutional power, and therefore given a verdict accordingly. But it involves a case where deeper political implications were involved, and that became subsequently evident, even with respect to the institution of judiciary itself. Now, a prominent case which came up before the court subsequently during the Janata government's time was when the Janata government decided to dissolve certain state legislatures run by the Congress party, by saying that there is a huge mandate against the Congress party, and therefore that could be the reason for those governments to, the state governments to dissolve, and therefore a president's order was issued accordingly. Even in the dissolution case, the Supreme Court, because of the mandate given to the Janata Party by the people of the country, was therefore not suggesting that there was a malified intention behind that presidential order. So, accordingly it upheld the dissolution order. But in the subsequent judgments, for instance in S.R. Bommai case, the use of Article 356 power had been clearly outlined by the Supreme Court, suggesting that if secularism, one of the core features of the Constitution, is at stake, then that could be a reason for imposing president's rule in the states, and therefore justified the dismissal of the state governments, of the BJP run state governments in the aftermath of the Ayodhya incident. And to that extent, the Supreme Court discussed at length in S.R. Bommai about federalism and secularism, and to that extent one can see that the Supreme Court charted out the agenda for the political parties to understand the way the Constitution was imposing these ideals which should be part of the governance of the society of India. And therefore, S.R. Bommai had become a landmark judgment which outlined these features as the essentials of a democracy and therefore of governance, and cannot be compromised at the whims and fancies of different stakeholders. However, there were instances where the court had developed another line of argument. For instance, in the election petition cases, for instance, this is otherwise known as the Hindutva cases, the Supreme Court had developed a line of argument to suggest that Hindutva is a way of life. So, if one is appealing on the basis of Hindutva, that is not an appeal on the ground of religion, and therefore constitute a corrupt practice under the Representation of Peoples Act. It is rather that it is suggesting about a way of life, and therefore it is no, and therefore that is not going against the religious sentiments of anyone. There are scholars who have criticized this Hindutva line of argument developed by the Supreme Court, to what extent that is therefore contesting the individual and group rights of people, or minority rights for that matter. But there are a number of election related cases which deeply brought into focus the political questions which were involved. The political course of action could be devised, and these were decided by the court ultimately. So, the line in between a legal question and a political question to that extent becomes a blurred one when these kind of cases come up before the court, which have serious repercussions for democratic traditions of the country. And as far as India is concerned, it is still an evolving democracy. There are arguments that it did not have a democratic tradition to say in the beginning, but over the years it is developing a tradition of its own in terms of vibrant democracy, for which the essential ingredients of that democracy need to be strengthened time and again. There are issues of black money which were brought into consideration before the court. Again, it shows about how the nexus happened among criminals and political parties, the funding of political parties during election campaign, how the campaigns happened, the kind of speeches delivered by the politicians during the election campaign. All these were matters which were there for perusal of the court and a closer scrutiny. In some cases, the court had given order to the executive branch of the government to suggest to constitute the necessary inquiry. It had looked into the matter of appointment of the very appointment of CBI officials themselves. It has also brought into focus that on the one hand we give free and fair elections as part of the democratic ideals, but then on the other hand we are not ensuring that people would have the option of not exercising, not preferring to cast their vote in favor of any of the candidates. So, there was recently decided case where the Supreme Court said that a nota option should be provided by the Election Commission, and it gave directions accordingly to the Election Commission to work out these nota option in practice. By saying that free and fair elections is forming part of the basic structure of the constitution, and to that extent when people are not given an option of casting no vote in favor of any candidate and the secrecy of the same being kept is being ensured, their free and fair election is itself being compromised. But on other accounts and also the court recently in another case have criticized the political parties becoming a safe haven for the criminals, and the next is the criminality of the political the individuals within the political parties need to be closely monitored, and accordingly necessary measures need to be taken. To sum up, therefore, there is no gain in saying that the law, politics and court are separated from each other. Every political question which has legal ramifications or which have deeper impact on constitutionality would invite the attention of the court, and the court cannot shy away by saying that this is only a political question. And to that extent, law and politics and the judicial process involved in the whole exercise is clearly interrelated, and there are a number of cases where the Supreme Court has taken up that position very clearly. Though there are also cases where the Supreme Court took a back seat, but it is also to suggest that there is no separation of law and politics possible, because politics and governance are matters in which the law plays a stabilizing role, and to that extent the judiciary has a pivotal role to play in order to bring in that stability and charting out a course of action for the future for an evolving democracy like India. Thank you.